clerk will open the court.
Oyez, oyez, oyez. The Honorable Court of Criminal Appeals is now in session.
Good morning. The COVID-19 pandemic required many adjustments of the justice system. Social distancing and group size restrictions, as well as substantial hardships on counsel traveling to Austin, do not allow us to hold arguments in the courtroom. Rather than submit cases without argument, we have decided to proceed through remote connections. Court staff and staff from the Office of Court Administration have made every effort to prepare us and counsel, but of course there may be glitches that will require patience. Otherwise, we will proceed as we would in person. The arguments are being live streamed this morning and a recording will be available later today. We're ready to hear argument in cause number PD-0963-19, Harry Donald Nicholson, Jr. versus the state of Texas. You may proceed.
Thank you, Your Honor, and may it please the court. This is yet another case in which this court should hold that when interpreting statutes, it is the literal text, the plain language that is the beginning and end of the matter.
Excuse me, counsel, can we go back a minute and you state your name for the record?
Yes, I'm sorry, Your Honor. I'm Brett Ordway here on behalf of Harry Donald Nicholson. Did that come through? Okay. Here under section 3804 of the Penal Code, a person commits an offense if he intentionally flees from a person he knows is a peace officer or federal special investigator attempting lawfully to arrest or detain him. There is nothing ambiguous about this language. We know that the word knows travels the length of the statute, and that the state's job would be easier if lawfully were in parentheses does not make it absurd that it is not. And critically here, this is not a hypothetical.
Are there any scenarios in which if we adopt your reading that the state would ever be able to prove that the defendant knows he's being lawfully arrested?
Yes, I think that in almost any circumstance, I think it's not going to be difficult for the state to prove it at all. And I think that really that is the core reason why the statute is written is not absurd at all.
Well, here though, isn't it pretty clear that he knew, since, I mean, he knew he made bond. He knew that, somehow he was he knew he didn't show up when he was supposed to. And so isn't it fairly clear that, from all the surrounding circumstances that he knew exactly what was happening? Come on.
Well, so I don't know that it is clear that he knew that there was a warrant out for his arrest. First of all, I think that there is a difference between showing that someone missed a court date and showing that someone skipped a court date, knew they skipped a court date, and knew that a warrant would issue as a result of that. And I would point to the court in the video of all of this, you'll see that when Officer Layfield is handcuffing Mr. Nicholson, Mr. Nicholson says over and over again, why are you doing this? Why are you doing this? And so while certainly the state did a very good job of showing that there was a warrant out for his arrest, I think that's a different thing than showing that he knew there were warrants out for his arrest.
I guess what I was trying to get at earlier with my question, though, is that, look, detentions can be lawful based on a lot of different circumstances. And sometimes it's hard oftentimes for officers to know, and they do this all the time, whether or not their detention is lawful. They make mistakes and things like that. So how is the state supposed to be able to prove a defendant would have the kind of legal acumen to know when he's being lawfully detained?
Well, so I think it's a critical point here that we're not saying that a defendant needs to have graduated from law school and taken CLE to know that he's being lawfully detained. I want to quote from the state's brief here. You can show knowledge of lawfulness the exact same way you show knowledge of anything else. And that is based on a series of reasonable inferences from the evidence. Every day across this state in courtrooms, we talk to veneer panels about how we can't pull back a defendant's head and know what they're thinking the moment they did something, the moment they pulled the trigger. but we infer what they're thinking based on a series of reasonable inferences. And it's just the same here. You prove a defendant's knowledge of lawfulness circumstantially the exact way you prove anything else. And so if you had a circumstance where a defendant had just committed a very serious crime, the hypothetical I always think of is that if you want to argue that you can't be arrested as you're exiting a bank you've just robbed, that you didn't know that that was a lawful arrest, well, then I wish you the best of luck. But I don't think that the state is going to have any difficulty persuading a jury that you knew very well that you were being lawfully arrested or detained as you walked out of that bank. And so that's exactly how the state can prove this. We are not arguing that you have to be an expert in criminal law to show knowledge of lawfulness.
What about in cases of involving, for example, a traffic stop for something not so obvious, you know, maybe a tail light is out, for example, and the officer's doing so not necessarily because a crime's been committed, but because he's doing it for the safety of the person driving the automobile, for example, which, you know, community safety is something important that police officers can take into consideration. And so if a person decides to just take off and always has the argument that, well, I did not know that the officer's actions were lawful, then where does that put the state in terms of law enforcement?
Well, so I have a few responses to that question. So my first response is that a person certainly can get on the stand and testify that he didn't realize the arrest or detention was lawful. But again, that's ultimately a fact question for the jury to decide. The second response to your question is that—
But going back to that, Mr. Orway, as Judge Uri was saying, if someone doesn't know they have a tail light out, I mean, that's, you know, that you're saying it's credibility. Well, I didn't know I had a tail light out. I mean, that's certainly a credible argument. So are you saying that can never be evading if then a police officer is trying to pull them over and they just keep going and refuse to pull over because they don't think it's lawful?
Well, so I'm not saying it could never be evading. I am saying that it might not be evading. But in preparing for this argument, I thought about that exact scenario and that it could be kind of problematic. And then I remembered that under the transportation code, there is another offense, fleeing or attempting to elude a police officer, that does not require knowledge of any sort of lawfulness. So if you're in your car and an officer pulls in behind you and turns on his brights and you don't realize your tail light is out, that is not a defense to the Class B misdemeanor transportation code offense for failing to pull over. So there's not some gap in the law that allows for people to say, forget this, I'm not pulling over when an officer pulls behind them on the road when their tail light is out. And I do think that, you know, that is going to be a rare circumstance. If you have a case where someone is going 90 down the highway and the officer pulls him over, again, I think that's going to be very difficult to persuade a jury that you didn't know you were being lawfully pulled over.
I think that what all these questions are trying to get at is, if this reading of the statute is absurd or leads to absurd results, and one of those absurd results could very well be that the legislature has passed a statute that ultimately can't be enforced, then maybe we have to look at a different construction than the one you suggested.
Right. I think that if it couldn't be enforced, then that would be a real problem for our argument. But I think that it can very easily be enforced. And I think really a great demonstration of how easily this can be enforced, at least from the state's perspective, is that if you just look at the state's brief before this court in this case and compare its response to our first issue and our second, it takes about 20 pages to get through the first issue and 3 very tight ones to argue that the evidence is legally sufficient here. We, of course, disagree, but the state does not seem to have had any difficulty whatsoever making its argument here. And the Court of Appeals, of course, had no difficulty in concluding that the evidence was sufficient here too. And this really is an outlier case, I think. I think here, under the unique circumstances, the state did not show that the evidence was sufficient. But in almost every other case, I don't think it's going to be a problem at all, because again, you can infer knowledge of lawfulness from the surrounding circumstances like you can infer knowledge of anything else. If I can talk a little bit about the state's argument that the statute is ambiguous, which is the alternative basis on which the state urges this court not to follow the plain text of the statute. This is an argument the state makes for the first time in this court. The state has never argued that it was ambiguous before, but here the state advances these two alternative readings that it contends are reasonable readings. The first is this restrictive clause unto itself reading. I think we pretty well addressed this in our letter brief that we filed last week. But in short, this is the idea that everything that comes after person, well, maybe it's two restrictive clauses. And in that case, they would both independently modify person, and knows would be confined to the first one. Just briefly, as we set out in our brief, even if they are two restrictive clauses, not one larger one, it doesn't matter, because the second modifies the first, modifying the word person. It's like when you have the big red dog. Red modifies dog, big modifies red dog. So that is no reason to find the statute ambiguous. The second alternative reading floated by the state, I think, is somewhat more interesting, and that is the idea that lawfully is a parenthetical that lost its parentheses somewhere along the way. I think that if imagining alternative punctuation is all that it takes to make a statute ambiguous, there are going to be many more statutes coming this court's way. Some that immediately came to mind for me were the self-defense statute, which considers what a reasonable person thinks about another's use of unlawful force. The enticing a child statute looks at an intent to interfere with lawful custody. In both of those statutes, like this one, we could imagine that unlawful or lawful was in parentheses and totally change the meaning. I don't think that the court would conclude that those statutes are ambiguous, and I don't think that the court should do so here either. One other point I want to make on the ambiguity is that even if the statute was ambiguous, this court has said over and over again, in the Ross case from last year, in the Tom DeLay case notably, and dating back to the McQueen case in 1983, that in the face of a statute that is ambiguous with respect to the extent of the mens rea requirement, we have resolved the ambiguity in favor of applying culpability to the conduct elements which make the overall conduct criminal. And so here, what makes the overall crime, or makes the overall act criminal, is that you are fleeing from a police officer who's attempting to arrest or detain you. Just running away from a police officer on the street is not an offense. So under DeLay, Ross, and McQueen, this court should resolve any ambiguity by taking the culpable mental state of knows and applying it to the attempted arrest or detention.
Right, but that doesn't necessarily mean that knows has to apply to lawfully. That just means that you're applying it to the conduct of attempting to arrest.
So, well, I don't know how this court could reach that conclusion without just ignoring that lawfully is embedded within that phrase. The state argued in its brief that we might be in a better position if lawfully were in front of attempting, which I don't really agree with. I mean, from my perspective, the fact that lawfully is buried within attempting to arrest or detain really supports our reading that if knowledge has to get to that part of the statute, then it has to get to the lawfully within it. I just have a couple minutes left, so I want to turn to applying the plain language of the statute to the facts here. And because it wasn't just the warrants, the Court of Appeals identified a couple other reasons that Mr. Nicholson should have known that did know that his arrest or detention was lawful. The first is that there were some pipes later found in his center console. The state in its brief before this court acknowledges that that is no reason for Mr. Nicholson to know his arrest or detention is lawful, because those were never found until after this whole unfortunate ordeal had concluded. There's no evidence of any strong odor or anything like that. The next two things really go together, and that is that Mr. Nicholson had thrown some Kleenexes out of his truck and that he did not have his physical driver's license. So these things go together, I think, for two reasons. The first is that they are, of course, very minor offenses, Class C misdemeanor offenses that I don't think many of us would expect to be handcuffed for. But maybe more importantly, what these two offenses have in common is that they were both, for lack of a better word, resolved. The littering was the very first thing that Officer Layfield brought up when he approached Mr. Nicholson's car. Mr. Nicholson said, yes, those are mine, I'll clean them up, and he moved on. Similarly, with the driver's license, he said, I don't have my physical license, but he rattled off the number. It was pretty impressive. And the officer moved on. So maybe one of these things wouldn't be good enough, but together, that they're so minor and that they're resolved, they don't form a basis. And I see I'm over my time. So if there are no other questions.
Thank you, counsel.
May it please the court. My name is Emily Johnson-Leo, arguing on behalf of the state. I want to begin with a few of the points that appellant has talked about. And the first is the kind of proof problems that the state might have in prosecuting this. It's one thing to say that in a case like this, there's legally sufficient evidence to prove that appellant had knowledge of the lawfulness of his attempted arrest or detention. It's something else to say that a jury would have been convinced by it. And in many scenarios, you might have a very sincere defendant who believes that, even unreasonably, but believes, and the jury believes that sincerity, that he didn't know all the facts to make his arrest or detention lawful. And I think that's going to be the difference there. But not only that.
Well, can I ask you a question about that?
Yes.
What would prevent the legislature from sort of not wanting people to be punished if that was their policy decision, for example, for their attempt to evade a detention when they did not know that it was lawful? And from setting a high burden for the state to prove that they knew that it was lawful, and a lawful attempt by the officer. If that was the legislature's intent to do that, then what would prevent them from doing that? I mean, it seems like there's a suggestion that they're not allowed to do that because it makes it too hard for the state. And so I'm wondering if you can address that.
Yes. So I think that there is an idea, especially with evading as opposed to resisting arrest. There is this idea of to allow a defendant to have self-help, the remedy of self-help, and that if they think that the arrest or detention is unlawful, then the legislature has allowed the defendant to flee in that situation. But you don't need the defendant's knowledge in order to have that scenario, because
I mean, that you're raising, I'm sorry, counsel, but doesn't it does seem odd to me that you're making this comparison to resisting versus evading, and resisting affirmatively doesn't have this lawful requirement, but evading does, and it does seem very, and as your defense counsel noted, there is another statute for fleeing that doesn't require knowledge. So these things seem to suggest the legislature could have very carefully decided when they want to prove this lawfulness and when they wanted to prove knowledge of lawfulness.
Okay, so let me be clear. I think the best reading of this statute is that lawfulness is required. And I think that but I don't think that the remedy of self-help needs not the defendant's knowledge of the lawfulness in order for that still to be a remedy. Because in a lot of situations, when the arrest or detention is unlawful, that will be obvious. And when it's obvious, he will be able to flee in that situation. But he better be right. and that also gives the officer the same, actual. He'd also be right that it needs to also be lawful for him to do that.
Well, aren't we talking about an objective test here rather than subjective knowledge and of the fact that it's lawful, and the fact that he did, he was arrested, he did make bond, the address on the application and everything else is his address, and it's his name on there. Isn't it reasonable to believe that he knew from all the surrounding circumstances he was to show up, or a warrant would be issued for his arrest? Usually, don't the bail bondsmen explain that thoroughly to their clients and what have you? I mean, just looking at all the surrounding circumstances, isn't there enough to infer that?
Yes, I think in this case, particularly, there is enough evidence for a reasonable jury to come to that conclusion. The absurdity for the general case is giving that power over to the defendant to decide reasonably or unreasonably whether he believes that his arrest or detention is lawful. And I think that's the difference. Appellant argues that
counsel, but why is that absurd that the legislature could require knowledge of, say, violation of protective order? You need to know that there's a protective order out there. Why is it absurd to say that they could include this lawfully here when they've done it in other situations and then they've chosen not to do it in other situations? Why is that an absurd result, especially if you can prosecute someone for a situation just like this, where we have circumstantial evidence that shows he knew that he was being detained lawfully?
I think there are too many scenarios where it actually would encourage the offense of fleeing. If you take a gamble and you think later on you're going to be able to persuade a jury that you didn't understand that what he knew was what the officer knew made it lawful, and that undercuts the whole effectiveness of the statute. That's our reason for why it's absurd, and that sort of presumption against ineffectiveness makes our construction better. It also better harmonizes the rule that ignorance of the law is no defense. In addition, I would definitely disagree with counsel's interpretation on whether or not knowledge of the lawfulness is something that makes this offense criminal. Definitely, as far as where, how far along the line of the sentence the culpable mental state should travel is different between the fact that it goes to the knowledge that the officer is attempting to pull the defendant over or stop the defendant, and lawfulness. And here, lawfulness acts kind of like statute of limitations. It's a legislative act of grace to say, hey, in situations where it's actually not lawful, then you have that ability to flee, and it is not an offense. You won't be prosecuted for it later. You won't be found guilty for it later. But it's not the distinguishing fact between what makes an offense and what doesn't. So I think it's difficult to treat the word knows like any other word or grammar in the structure of the sentence, when this is the culpable mental state element of the offense. And we have this body of law that says you're going to extend the culpable mental state to the purveyment of the offense. You're going to extend it to the gist of the offense, the thing in a circumstance offense, to the thing that makes it criminal. But we don't extend it to every element. We only extend it to those that are necessary for that guilty mind. And that doesn't, in this case, extend to the knowledge of the lawfulness. It extends to lawfulness, but it doesn't extend it extends to attempting, the knowledge of the attempting, but it does not extend to his knowledge that that was lawful.
So I guess I see what you're saying, but it does seem a little bit of a contradiction to me to say it applies to attempting. It obviously has to apply to detaining, but it then jumps over the word lawfully, like the legislature embedded that in that clause. How is it that it can really apply to the clause except that one word?
Well, because I think it's when you're applying the culpable mental state, I'm not sure how much of this is strict grammar anyhow. It goes to the idea of what are the parts of the offense that make it criminal when it's a circumstance, or what are the parts that are the gravamen of the offense. And not only that, it's our position that that the placement of the word is an odd placement, because it separates out a verb from its direct object. It even sounds kind of weird to your ear when you say the phrase lawfully, attempting lawfully to arrest or detain. There's another similar statute, the smuggling statute, that incorporates evading into it as one of the manners and means of smuggling a person in Chapter 20 of the Penal Code. And it has the same string of the rest of the words of evading, but it places the word lawfully, it does split infinitive, right? Attempting to lawfully arrest or detain. Here in this offense, the placement of the word does suggest that there's something unusual going on. And that unusual thing that's going on could be that it's an aside, it's a parenthesis.
Counsel, to me, it doesn't seem like it's quite so complicated as you're suggesting. To me, it seems that the defendant just needs to know that the person's a peace officer or special investigator, and then the attempting lawfully to arrest or detain him then is really going towards the action of the officer or special investigator, so that they're the ones lawfully attempting to arrest or detain him, and then the defendant just needs to know that they're a peace officer.
And that's certainly one reading. I think that's the reading that that Chief Justice Gray would give. It probably goes against this court's opinion in Jackson, given that that's the same kind of string of words that the court interpreted that the mental state of knowledge had to go to attempting. But you could say the insertion of the phrase "or federal special investigator" sort of broke that interpretation. That is possible, but I think again the court would have to consider the culpable mental state and how far along it travels. And I think under that interpretation, dealing with that issue, I think it's because of the severity of this offense. I mean, it is a felony, that the culpable mental state could apply or should apply to the knowledge that the officer is actually attempting to arrest or detain them. I mean, I suppose.
Just to clarify, I want to make sure I understand. You're not saying, your argument isn't that the state doesn't have to prove that knowledge that he's being detained. You're saying the state still has to prove he knows that this officer is trying to detain him. Your argument is he just doesn't have to know that it was lawful.
Correct.
Okay.
I think that's the best reading of the statute, because I think ultimately when you're deciding culpable mental states, and it probably goes to that element of knowing that they're attempting to arrest or detain.
But you're also arguing that even if we don't go with that idea, that the evidence is sufficient anyway.
Correct. Yes. Given everything that's in this record, his jail calls talking about why he's in the situation that he's in, the discussions with him and his mother suggest that they know about this offense in Van Zandt that he didn't appear for. He says to the officer, his mother, on the day that he's arrested, "I told you I wasn't going to go if I didn't have to. I tried to get away." In all of this, his statements to the officer at the scene, "Come on, give me a break." His telling the officer, giving him his driver's license number, and then knowing that the officer is communicating with dispatch, all of the scenarios together suggests that this is a situation when the defendant knew that the officer's detention would have been lawful. So the court doesn't need to.
Let me ask you a question. Now, to go back to absurd results, let's assume for this question that the defense is right, that the statute is unambiguous, and that the defendant has to know that the attempted arrest or detention is lawful. Now, at first glance, when you read that, that might be hard to prove sometimes. But I also thought about this and I'm like, there's many situations with normal traffic stops where a defendant knows that the police officer has a legal right to stop him. Let's just say he's going 90 miles an hour and he sees the red lights behind him. Well, he knows he's speeding. So he knows it's a legal stop. Let's behind him. So he knows that the officer has a legal right to stop him. There's any number of situations like that. And it could be that these are the situations that the legislature intended in writing the statute and putting the words in there to indicate that he needs to know. So with that situation in mind, why would it be absurd for the legislature to write it that way, mean it that way, and yet, you know, say that it's not an offense unless it's just absolutely clear that the defendant knew that it was an illegal stop or a legal stop, excuse me.
So it's just the idea that it would be up to the defendant to decide whether or not he should respond to what the officer is doing. It gives over that decision of whether or not this is lawful, whether he believes that it's lawful, and whether or not he feels that he might later be able to convince a jury that he didn't know or didn't believe that it was lawful.
Yes, and I also think about situations to where police officers stop people for nefarious reasons on country roads, and you've got a woman driving down a country road and all of a sudden there's red lights behind them and they know they didn't do anything wrong. And they know that there's no reason that they can think of why this officer stopped them, and they are scared. So maybe there is no absurd results in the defense's interpretation of the statute and it not being ambiguous.
But I think in that scenario that you proposed, even if the knowledge element doesn't go to lawfulness, the fact that it has to actually be lawful means that the defendant in that situation, the woman who's driving the car, she has the ability to flee and not stop for the officer because it is actually unlawful. Yes.
I'm sorry. The lower courts now are actually interpreting the statute the way that you're arguing it should be interpreted, that there's no scienter requirement with regard to knowing that it's lawful, or no scienter requirement requiring it that it's lawful. And given some of the suggestions, particularly your argument about the sufficiency of the evidence, is it possible for us to just say, let's assume that we're going to go with his instruction, even under his construction, he's still guilty?
Yes. That would be the narrowest grounds for this court to decide the case, is to just find on the evidence that's presented here that knowledge was shown. I do want to spend just a minute talking about the punctuation issue, and I'm not saying that this parenthetic information, we should just pretend that parentheses are there or insert comments.
Excuse me, counsel. Before you get to the punctuation issue, am I correct that at some point several years ago, the word lawfully was actually added to the statute? It hadn't been before. And if that's correct, could it be that the legislature put it there in their own purpose?
So it used to be that when the statute was first passed, the very first time in 74, part of the penal code, evading had an exception for the lawfulness, that the state had the burden to prove that it was lawful, not that there was a knowledge element going to that, but that it was not unlawful. But as the way that lawfulness got into the elements, a plain element of this offense, was through the 1993 amendment. And that's on page 15 of the state's brief. It shows you sort of what is the strikeout an underlying section that the legislature was actually passing. And when they didn't just stick in the word lawfully, what they did was they said, let's take out the exception and add it as a plain element. And this is important because there were several other either exceptions or non-applicability statutes that were also changed at the same time as this moving from an exception to an element. There's still a lot of troublesome things that happen with exceptions and a reason to have that become just a straight up element, like it not being in the indictment in the first place, not getting into the jury charge. And also at that time, there was still a little concern about it still being a void indictment. So for these reasons
Counsel,
would be another reason to make it just an element. Yeah.
Counsel, so that's statutory history as opposed to legislative history. Are we considering the statutory history? Are we able to do that even if we think the terms are plain? And how are we supposed to deal with competing canons of construction?
Yes, so it is, if I see I am out of time, if I can just answer this part.
45 seconds, please.
So yes, it is part of, if you have multiple different ways of addressing competing claims, you look to the doctrines and canons of construction. And it's different part of the legislative history versus the statutory history. This is the text they were actually passing. Thank you.
Thank you, counsel.
Thank you, Your Honor. A few points I want to make. First, it seems to me that the state's argument repeatedly relies on treating things that are unusual as unheard of. So beginning first with the grammatical argument that attempting lawfully is unusual. That may be, but it is not grammatically incorrect. I am trying mightily to persuade you to rule in our favor here. There's nothing grammatically incorrect about that. Maybe more importantly, though, while it is certainly unusual to care what a defendant thinks about the law, it is not entirely unheard of, as Judge Newell pointed out. We do care about it in certain instances. The protective order context you talk about, there is, of course, a mistake of law defense in our penal code, which is narrowly constrained, but there are at least some contexts. And
Excuse me, counsel, but after listening to the state's recitation of the facts, I'm interested to know how you think there's no knowledge of lawfulness here.
Well, I think that there's no knowledge of lawfulness here, primarily because the officer never gave any basis for the detention. And that is why you see on the video. But
the knowledge of lawfulness that we're talking about here is not the police officers, it's the defendants.
Right, but the defendant, I don't think that the state showed beyond a reasonable doubt that the defendant knew there were warrants out for his arrest. The state showed that there were warrants out for his arrest.
What about all the jail calls and the conversations with his mother, et cetera, et cetera? We just ignore those?
No, I don't think you should ignore those. And regarding the jail call, I am fairly certain that jail call was in fact 1 week after the offense here. I will go back and check that, and I'll submit a letter if I'm incorrect there, but I'm pretty sure that was 1 week after. And if you listen to that call and the call that preceded it, you'll see that Mr. Nicholson had already spoken with his attorney about why he was now sitting in the Navarro County Jail. So I don't think that this jail call 1 week after this whole unfortunate ordeal at all shows what he's thinking at the moment when he is being detained 1 week earlier. And to Judge Kiesler's point, and we pointed this out in our brief, I think that one way the state could have proven that he knew there were warrants out for his arrest would be calling the bail bondsman. That is a non-impossible way to prove guilt here. And
But counsel, let me ask you this. Even if he knew absolutely, and his bondsman told him he had a warrant out for his arrest, is there anything in the record that means that the officer also knew? Because if the officer didn't know there was a warrant out there, then the arrest was illegal, even if there was a warrant, in my opinion. Maybe I'm wrong about that.
So I think that if there was no evidence in the record that the officer knew there were warrants for his arrest, then we would at least have a defense to the fact that the arrest or detention was lawful. That's similar to the hypothetical about the police officer harassing the woman on the county road. But here I do believe there was evidence that the radio dispatcher told the officer about the arrest warrants.
Okay, but also, isn't it true that the defendant's decision at the time of whether to stop or not, he has to know, according to the statute, the way you're interpreting it, that the arrest is legal. And just because he knows that there's a warrant doesn't mean that he knows that the officer knows at that point. You know, if there's evidence later that the officer knew, you know, aren't we looking at what the defendant knows at that point rather than just strictly what the officer knows?
We are, but I think it would be very difficult for a defendant to argue that, well, I knew there was a warrant out for my arrest, but how do I know what this officer knows? So I don't have to pull over. We are not advocating for such an expansive reading of the statute.
Okay, thank you.
If I could just conclude, I want to say that I think Chief Justice Gray really did say this best. We may not agree with the legislature. This construction of the statute may be ill-advised, and it may pose interesting challenges in proof for the state. But that does not make it absurd or illogical. The plain language of the statute requires proof of knowledge of lawfulness. The state did not show that here, and so we ask for a judgment of acquittal.
Thank you, counsel. The case is submitted. The court will stand in recess until 11 o'clock.